My name's Ashley Mascarello, and I'm obviously with Goodman Law. I've been with Clint for just over 2 years now, and this is my first time teaching a class. So thank you so much for attending, very exciting. And today we're talking about foreclosures, which I think I do a majority of the foreclosures in our office, so that's kind of why I picked this topic. It's something that I basically do every day. So we're going to dive right in. I also wanted to introduce my sister, Andrea Mascarello. Andrea Dees, sorry, she got married last year. That's my twin sister, so I know there's been some confusion. She used to work with Carpenter. She's now with us, so I think this is one of the first times that we've actually been out and about together. So setting the record straight, she's with us now. If you see her, she'll say hi, but she doesn't know anything about the law. So that won't be very helpful, but just so you guys know, we are together now. So that's exciting, and hopefully we'll clear up some of the confusion. All right. So foreclosures. How many of you guys, by show of hands, have been a part of foreclosure, had an account go to foreclosure, either with our office or someone else? Okay, so a lot of people. A lot of the times, at least in my experience, as I've been doing this, boards have a lot of the same questions over and over and over. And so the point of this class is to kind of go over a lot of those common questions, kind of do a very basic overview of when you can foreclose, what that entails, what the process is, because I know that once you guys send an account over to us, it's, out of your hands and we take it from there, but I just wanted to give you guys kind of an idea of what we do in our office so that if boards ask kind of general questions like that, you have a little bit better of an understanding. And then we'll cover some of the common questions and some of the common hiccups that we run into when we do foreclosures. So, foreclosure in Arizona is, as far as homeowners associations go, statutory based. As you guys all know too, as you've read enough CC&Rs, there's two obligations for owners as to assessments in the CC&Rs. One of those obligations is the personal obligation of the owner to pay for the assessments and the amounts provided for in the documents. That's not what we're really talking about here today, that owner's personal obligation. By that I mean that we can sue an owner personally and garnish their wages or garnish their bank account. That is a remedy that boards also have, but today we're talking about the second part of that that's found in the CC&Rs, which is the association's assessment lien and its ability to foreclose on that lien. So that's governed in the statutes by ARS 33-1807 for the planned communities and ARS 33-1256 for the condominiums. If you look those up, you'll see that they're identical provisions. They just govern, one governs planned communities and one governs condos. So if you look at the statute, the first thing that it talks about is what does the assessment lien consist of? What kinds of amounts are included in the lien? Because you can only foreclose on the amounts that are secured by the lien. So the statute lists out a few things. Obviously, number one, the big one, are the assessments or the dues. The association has a lien for the assessments, whether they're monthly or annual or biannual or whatever they are. The assessment includes late fees that the association charges if an owner is missing payments. Usually that's governed by the document, so if it's $15 or a percentage of whatever the actual assessment is. Reasonable collection fees. In my mind, I think of this as kind of the charges that you guys pose. So you guys send initial demand letters, that's $50 or whatever it is. Those collection fees are part of the lien. And then there's our attorney's fees and costs, which are part of the lien. You'll note that I didn't include fines, everyone's new favorite topic, fines. Especially with the recent case law, fines are really kind of mushy right now, but fines are not part of the lien. So when you send an account over to us, and if you have $1,000 in assessments, but $8,000 in fines, that you can't foreclose on that $8,000 worth of fines. you could potentially collect that personally from the owner as part of their personal obligation, but not part of the lien. So that, I think sometimes boards get confused about that. And if you see different amounts in like our letters, or sometimes in our complaints, we make a distinction between the lien obligation and the personal obligation. Usually that difference, if it's not the same amount, are the fines that are on the account. And then a side note here that I didn't include on your outline, but what's called the statute of limitations. So have you guys heard that term before? That's just how long you have until to sue somebody for something. So the statute of limitations for a general breach of contract case is 6 years. So I can reach back 6 years in the past on someone's personal obligation for breach of contract. For a lien, the statute of limitations is 3 years. So we can only reach back 3 years from the date that we file our complaint. So if we're filing a complaint today, we can reach back through October 2015, and that's it. So if there's assessment charges that are from 2014, we can't include those in the lien. We can include them in the personal amount, because that's within 6 years. So that's also another distinction, that if you see two different amounts there for a personal obligation versus a lien obligation for owners. Oops. Okay, another thing that the statute makes clear, and that sometimes boards don't realize, is that an HOA's assessment lien, according to the statute, is automatic. This means that you don't have to record a notice of lien against an owner in order for the lien to be effective. The statute says that when the declaration or the CC&Rs are recorded, that's the perfection of the association's lien. There doesn't need to be an additional notice of lien recorded in every instance. I know that some boards like to do that because it shows up when you do a title search or something like that, but it's certainly not required. It's almost like a preference sort of thing instead of a requirement. If some boards are really conservative and they want to do that, we certainly don't discourage it, but it's not a requirement. And then the other thing that the statutes touch on is called priority. So that has to deal with, of all the encumbrances that can be recorded against a particular lot or unit, where does the association's assessment lien fall? The good news is that we're pretty up to the top. We're not the very first tip of the top of everything, but we're up there. The association's assessment lien is superior to any other encumbrances except for 3. And really, only 2 of them are ever applicable, because one of them has to do with any encumbrance that's recorded against either the debtor or that lot potentially before the declaration is recorded. That one rarely comes into play, because a lot of time we have CC&Rs that are recorded in the 60s or 70s, and usually current owners don't have any encumbrances that are going to predate that CC&R recording date. So that one's very rarely in play. The other 2 that have priority over an association's lien is what's called a first deed of trust, or the mortgage that's recorded on the property. The bank is ahead of us in line. And then 2, the state, of course, has to get ahead of us, and they, like any tax liens that are recorded against the unit is how the statute refers to it. So if someone hasn't paid their taxes for a couple years, any liens that are recorded against that unit or that lot will take priority over the association's lien. So will the mortgage. Anything else, we are superior to them. So that includes things like a recorded judgment that some other creditor, like a credit card company, or if someone's friend sued them for rent. Any of those recorded judgments will take back of the line to the association's lien, which is helpful to us because when we foreclose, a lot of the other encumbrances will be wiped out in that process, and it helps the association recover those costs because it doesn't have to worry about being third, fourth, and fifth in line in certain situations. So that's some good news. Yes.
When you say tax liens, does that include federal income tax?
Good question.
Or just property tax?
That's a good question. Because the statute says against the unit, there's an argument that federal taxes, which are personal, federal income taxes, those aren't taxes that have anything to do with a piece of property. So it's our position that no, federal income tax liens are not superior in position to the association's assessment lien. We always name the IRS in our foreclosure actions if that comes up. We have had the IRS come back and say, we think we're superior because of this exception, and it is recorded against the unit because our notice of lien attaches to any property. We haven't had any boards that have wanted to challenge that any further and actually litigate it, and so far there's no cases in Arizona that deal with that. So it's kind of an interesting question. I think we would have a good chance of prevailing just because of the specific language. It's not any and all tax liens. It's tax liens against the unit. But there's nothing definitive yet.
Okay.
But the way we handle it is we do name them in a lawsuit, which means that they're inferior to the association's lien. Okay, the last thing that the statute deals with is eligibility. As you guys know, not every account can be foreclosed. You can't just foreclose on someone for having $2,000 worth of fines or $500 on their account. The statute says that in order to be foreclosure eligible, the debtor has to owe at least $1,200 or the account is delinquent for 1 year or more. A lot of people always remember the $1,200 part. A lot of times directors come up to me and say, and they think it's just the $1,200. But there is that or in there. And that's important because that comes into play if you have associations where the assessments aren't that high. For example, we have one association where the assessments annually are about $260. They pay $130 twice a year. So someone cannot pay for 2 years and still not even be quite up to about $800 or $900, which is not the $1,200 threshold. And that's a problem because the association's not getting money for 2 years. They can't really, that's something that they're losing out on. That's why the 1 year is important. And then to also keep in mind that the statute of limitations is 3 years. So you have to be diligent in those cases where you don't want to wait too long to send it over to us, lest the 3 years runs. So you kind of want to get it just right. If it's approaching that 1 year where the owner hasn't paid any amounts, that's something to keep an eye on. Okay, with those statutory requirements in mind, what I want to do next is go over the process of foreclosure that we take in our office. And you'll note in your materials here, the first page kind of covers what we just covered as far as statutory requirements and all of that. The back page kind of shows the process that we're going to talk about and the time frame that those different steps take. It's a little bit involved, and the time frame is our best guesstimate. Obviously, sometimes things take longer. Rarely do they take shorter, as I'm sure you've noticed. But that's kind of an overview of the process. So what happens when we recommend foreclosure? The first thing that we do, if the board kind of gives us the thumbs up to either go ahead and go forward with the foreclosure, or at least take the first step towards that, is we order what's called a litigation guarantee. And that is a document that our title people put together that pulls for that lot and for those debtors. It shows us what other encumbrances are recorded against that piece of property. That's helpful for a couple of reasons. Number one, it shows us if there are any tax liens that we need to be aware of, if there's a mortgage recorded against the lot. And then what other encumbrances are there? Does this person have judgments recorded against them? Do they have federal tax liens recorded against them? We need to know all that information because if anyone is inferior to the association's lien, they need to be named in the lawsuit so that their rights can be extinguished if this property sells. Because they're, behind us in line, they get wiped out. So that's the first thing that the litigation guarantee will tell us. The second thing it's helpful to show is, like I said, if there's a mortgage reported against it. If there is, we pull the first deed of trust, which shows us the principal amount that was taken out, that the loan was taken out for. We don't at that point, this is a common question that we get, well, how much is left on that mortgage? There's no way at this point for us to tell that. But what we do is we can compare that mortgage amount with some property valuations, especially on like the assessor's website, and compare those to see if we think there's equity in this property. Equity is important because the more equity in the piece of property, the more likely it is that someone's going to bid on it at a sheriff sale. No one wants to buy a property that's encumbered with $400,000 if the property is only worth $100,000. So if it's a little bit wonky like that, we put that in because we write up a foreclosure memo, and we'll put that in the memo and say, just so you know, there might not be equity here, and that means that someone might not bid on the property at the sheriff sale. And we'll kind of get into what that means and what the ramifications of that are, but we do include that, and that's where we get that information and do that comparison. We do the foreclosure memo. We send that over to you guys to help the board kind of understand. And the foreclosure memo is nice because it basically has all the information I'm talking about today. I think that the boards don't really read them because then they email me with questions that the foreclosure memo answers. So that happens. It's about a 3-page document, so it's a little bit long for folks to kind of look through, I understand. But if you guys are ever wondering, a lot of it is broken down in the foreclosure memo. And if you have any questions, we can walk you guys through that memo as well. Let's see. After we send that foreclosure memo, if the board hasn't already, once they give us the green light to foreclose, we file the complaint. And like I said, we name the owners, how many ever owners there are listed on the deed, plus anyone that has an interest that's inferior to the association's lien. So someone has a recorded judgment and all that stuff that we've already talked about. Then we serve all of those individuals, wait for them to file their answers, or usually what happens with the junior lien holders is that they will file, with us, we'll file a stipulation to priority. Because we're not requesting that any of these junior lien holders pay the amounts for the debtor. We're just asking that they stipulate that our lien is superior to theirs. So that's how we usually deal with those junior lien holders that we name. Otherwise, there's kind of 2 scenarios that happen from here. Either the debtors answer, or they don't answer, right? And they have, after they're served, they have 20 days to file their answer. If they don't answer, that's kind of the easier route, so we'll start there. If they don't answer, we will get what's called a default judgment, which I think some of you have probably heard us talk about. That just means that no one answered, so the association wins by default. It's pretty easy. There's a process to do it. There's rules that we have to follow. We set a hearing with a commissioner at the court, and then we kind of fill the commissioner in and say, here's where we serve them, here's any communication that we might have had with them, either before or after the lawsuit, but they haven't answered and we haven't heard from them since. And the judge will go ahead and sign the judgment if they're satisfied with the efforts that we took. So that's kind of the easiest path of least resistance where no one's participating, obviously. We usually are able to obtain a judgment within probably about 60 days after filing the complaint if no one answers. If the debtors answer, a lot of the times they appear pro per, which means they don't have an attorney. This always makes for an interesting case, because usually in their answer they claim a lot of weird stuff. Like a lot of the answer forms with the courts, I don't know if you guys have ever seen them, but they're like check boxes for defenses. And so one defense, I don't know if you guys have heard of it, is called duress. A lot of them check duress because they feel like they're being forced to pay against their will. But duress is kind of, it's for a different context, so it's always pretty funny. Anytime if you get an email from me that says this person's filed an answer, you should take a look at the answer because they're usually a little bit wonky. But because there's not a lot of defenses that debtors can make in these kinds of cases. Either they paid the amounts and somehow we didn't get them, or they didn't. There's not really a argument that, number one, you don't have an obligation to pay it, because you do. That's in the CC&Rs. Or even the CC&Rs most of the time prohibit any sort of argument about, well, they're not maintaining the landscaping, and the association doesn't do crap for me, so I don't have to pay. Has anyone heard that one before?
No.
Probably never. But that's not a defense, and the law is clear about that. So what we do in these cases where the debtors answer is we file what's called a motion for summary judgment. And that's just a motion that gets filed with the court that says, number one, there's no facts in dispute here. The CC&Rs are a contract, they say what they say, this person hasn't presented any proof that they made payments, so number two, the association is entitled to judgment. The owners have a chance to respond to that motion. Sometimes they do, sometimes they don't. And then if they do, we have the last word. We file what's called a reply with the court. And then the court will either rule on the motion from there, or they might set it for oral argument, and then rule from there. I'd say 9 times out of 10, judges grant our motions for summary judgment, just because it is pretty quick cut. Unless the defendants, like I said, are able to produce evidence or raise questions of fact that are of issue, the court will sign the judgment at that point. And then we'll request our fees from the court and go from there. Once we have our final judgment in the case, from there, the judgment and all the other documents that the sheriff needs are sent to the sheriff's office. And it's then the sheriff's job to set the sale date. That usually takes about 30 days after the judgment is signed. We wait a 30-day period to send the judgment to the debtors, give them one last chance to contact us, because once the sale date is set, the debtors, if they want to stay in the house, have to work through with the sheriff's office and pay off the amounts in full with the sheriff. From then, it's pretty much out of our hands. So that's when it gets pretty serious. So one thing that I will say is I don't go to a lot of sheriff sales. We file a lot of foreclosure lawsuits. I would say, I was trying to think about this morning. In any given year, I would say I attend maybe 20 sheriff sales. We file a lot more than 20 foreclosure lawsuits. So I think if we file 10 foreclosure lawsuits, after someone is served, I would say 7 out of the 10 contact us to either pay in full or to set up payment agreements. So a lot of the times, some of these don't really even get off the ground because people say, oh crap, I've been served with a lawsuit, this escalated, I better reach out to them. So that's kind of the good news, is that not a lot of people are actually losing their houses when we do this, because they do reach out to us. Another thing that I've kind of been asked about from boards lately is, well, can we still work with people once the lawsuit is filed? The answer to that is yes. We're always more than happy to set up payment agreements, reasonable payment plans that are paid off in a reasonable amount of time, even if we've already filed the complaint. In those cases, we'll file another document with the court called a stipulated judgment, which outlines those payment plan terms. And as long as the owner stays current with that, they'll get everything resolved. They're not going to lose their house. Even, like I said, up until the point where the sale is set, people can call us post-judgment after we have a signed judgment from the court, and we'll still set up payment plans. We just want to get the association their money. We're not out here trying to take people's houses.
Do you set up payment plans, or the board has to approve it?
Yes, correct. So that's a little bit about our process through the sale date. From there, we're going to talk a little bit about what happens once the sale is set and the possibilities at an actual sale.
Did it die?
Might have died. So
Try
at a
again.
sale, there's really two potential outcomes. Number one, a third party bids. Number two, nobody bids. Right, so that's pretty simple. Like I said earlier, the number one factor of whether someone bids or not is equity, whether they're going to be able to get something out of this property or not. At the sale, we send the sheriff a copy of our judgment. The judgment also includes interest. So right before the sale, the sheriff emails our office and says, what is the total amount of your judgment plus interest? We send them our amount. They add the amount of their sheriff's costs, because there's costs for whatever the heck that they do in their office, set the sale. At the actual sale, the opening bid is always the amount of the judgment plus the interest plus the sheriff's costs. So if we ended up with a judgment for $8,000 and we had $1,000 of interest plus $1,000 of sheriff's costs, which is never that high, but math is hard and that gets us to a 10. So $10,000 is the opening bid for this piece of property. So from there, it's kind of up to whether anyone's interested in it or not. I will say that in the past 3 months, I've gone to a few sales, and at those sales, there's been a lot of bidding. So if it started at 10, most of ours have gotten up to like the $7, $8, $90,000 range, just because there's so much interest. So if a third party is interested in it, they bid. If other people are interested, it's really like an auction that you see. And then whoever, bids the highest wins. They then need to pay that whatever amount that they bid to the sheriff within 5 business days in either cash or certified funds. If there's multiple people interested and that first person fails to pay within that 5 days, they'll go to the second person. And if you do that too many times at the sheriff's sale, you get kicked out. So you can't just be like $100,000 and then you get out. You can't do that, or they'll get mad at you. From that date, that new owner is entitled to possession of the unit. They're now responsible for the assessments moving forward, but also keep in mind that if the unit or the lot is occupied, if it's not vacant at the time of the sale, there's also a 6-month redemption period in play, meaning that the now former owner, the person that we sued, can pay the amount that the property sold for within 6 months from the date of the sale. So a deed won't be issued to this new owner until 6 months down the road. If it's a vacant unit, they shorten that to 3 months. So that's also kind of in play in the back of everyone's mind. But for all intents and purposes, the association is getting that money. So if we have our judgment plus interest plus costs for $10,000, the sheriff will take out its costs, we'll send a check for $9,000 to our office, we'll process it out, take out our fees, then that's how the association gets its money back from that check from that third party. Yeah.
Where does the excess money go?
Good question. So you'll note that in our hypothetical, if we're getting $10,000, but this person bid $90,000, there's an $80,000 surplus. A couple things can happen. The other creditors, if there are any that we wiped out, can apply to get a piece of that pie. Otherwise, the now former owner can also apply to get interesting. But as far as the association, they're getting everything that they were entitled to, so there's nothing really else that they would be in play for. It's almost similar to, if you guys are familiar with trustee sales, where the bank forecloses and there's excess proceeds there. Even though the association's lien is extinguished in a trustee sale, if there are excess proceeds, we can try and get a piece of that pie. And again, good news, we're pretty much first in line unless there's tax liens. So if a third party bids on a piece of property, they do take it subject to anything that was superior to the association's lien. So they would take it subject to any tax liens that are on the property, and they would take it subject to whatever mortgage is on there. And so that's why I don't know how, I would love to sit down and chat with someone that, because there's people that attend sheriff sales, like, they're always there. I don't know what research they do or how they know if there's a way that they're able to tell what's left on that first deed of trust. But it's kind of interesting, and so they take it subject to that. And that's true as well if nobody bids at the sheriff's sale, which does happen. In that case, the property reverts back to the homeowners association. And the association becomes the owner of that unit. A lot of the times, the boards, this is worst case scenario for the boards, because we're like, great, what are we going to do with this lot? Okay, it's a little bit odd, but as the judgment creditor, technically they're the new owner, which is, in this case, the entity, the association. Another bummer about the association being the owner is that since no third party is paying the sheriff, which then sends a check to us and we take our fees out of that check, the association is responsible for our attorney's fees and costs if the property reverts back. So that, a lot of times boards don't understand that, and we're trying, this past year, we've been trying to make that a little bit more clear, because there's no funds that are coming to pay. So instead of getting the check from the sheriff, the association, as in for payment of this person's debt, they're getting a piece of property, but they're responsible for paying out the amount of our fees that were awarded. So that's a little bit tricky.
But
yeah.
Most times you've gotten most of your fees anyway because you bill monthly. Right?
A lot of our accounts, we don't bill monthly.
Oh.
A lot of them are on a no-cost plan, where we don't bill anything to the association, we're just trying to collect from the owner. And so unless it's hourly, you're right, you make a good point. If it's something that's been paid along the way,
Right.
No problem. But if it is no cost, that kind of comes to a surprise to a lot of boards that says, hey, I thought you were collecting from the owner. Well, we were, but we kind of reached the end of the road, and here we are, and now you have to pay us. So that can be an uncomfortable conversation. But what I was saying earlier about the mortgages, the bank's first deed of trust still being on the property, the association as the owner takes it still subject to any first deeds of trust or any tax liens. So that means that the association at the end of the day could end up with a piece of property, and then a month later the bank that's still reported encumbrance on the property can come in and foreclose. And then that's really worst case because the association didn't get any money, now they don't have a piece of property and their lien's extinguished because the bank foreclosed. So that's definitely a tough situation. I will say that there's no affirmative obligation for the association when they do become an owner to pay the bank anything to avoid that situation. I've never had an association reach out to the bank to say, hey, what can we do? Usually we just kind of wait and see what happens, because if the bank doesn't foreclose within 6 years since the old owner stopped paying, which we have to figure out when that is, if it was as of the date of the sale or if they haven't been paying for a couple of years, potentially the association can get the property free and clear, which is sort of a light at the end of the tunnel, but the bank really has to be sleeping on its obligations to foreclose. So that's a little bit tricky. Same goes for tax liens, but tax liens aren't as cumbersome, because usually a tax lien might be $2,000, maybe $5,000 if the interest rate is high. So it's not like you're dealing with $200,000 or $150,000 mortgage. So sometimes, every now and then, boards will say, oh, we'll just pay off, if the tax lien's $900, just pay that off, now we have it, if there's no mortgage, free and clear. The association, if it owns it free and clear, can sell the house. They can try to sell the house if they really wanted to with the mortgage on there, but I don't know if anyone's gonna buy a house, with the mortgage on it already. Or they can rent it out. And that's what a lot of our associations do when they end up with units or lots, is that they rent it out to the former owner and say, okay, you can stay here if you want, but you have to pay us rent plus continue to pay assessments. A lot of people don't do that because the point was to get these people who aren't paying out. But you can rent it to other tenants. You can hire a professional company to manage that for you if you're not in the rental business or if you don't want to deal with it. But we do have some of our associations that do that. So this leads us to our common questions. Cost, which we were just talking about, which can be a bummer. So usually our foreclosures cost for our attorney's fees and costs somewhere between $5,500 and $6,500, and that's from complaint to sale. It can get up from there depending on if the debtor does answer and it's really contested for some reason, if it's a super complex issue, or if there's a lot of junior lien holders. Like we just filed one where there's I think like 7 junior lien holders where it's just judgment for this, judgment for that, judgment for that. So that would be a little bit higher in cost just because there's more parties to serve and more people to resolve claims to. So that could cost a little bit more and take a little bit longer. The approximate time, I would say best case scenario is somewhere in like the 3 to 6 month range. Then again, we have those that kind of go longer than that if there's payment plans that were proposed that we're waiting to hear back from or situations like that. But if we don't hear, if it's just we file it, we don't hear from anybody, there's no one else to serve, we're just going through, I would say that would take about between 3 and 5 months depending on when the court schedules their hearings, when the sheriff schedules its sale. Let's see, we already kind of talked about this next section here is, what about the bank on the slide there? Like I said, there's no obligation to pay the bank if the association owns it, but the bank can foreclose, so that's kind of a risk. If a third party owns it, I believe they work out the deal with the bank, although I've never talked to anyone about that in any length, so I'm not really sure what that looks like. And the last thing I want to talk about are common hiccups, and these are the things that really kind of derail the process that I just outlined a little bit ago, and add to the time that a foreclosure would take. So the first one is bankruptcy. Bankruptcy is tricky because whether it's a Chapter 7 or a Chapter 13, no matter where we are in the process, we have to put a hold on everything. Whether we've just filed the complaint, whether we've just obtained the judgment, it slams the brakes on our entire process. So Chapter 7s usually take somewhere between 4 and 5 months to get resolved. Those are the shorter ones because the person is asking the bankruptcy court to discharge their non-secured debts. A Chapter 13, on the other hand, is where the debtor is going to try and repay their debts and set up a payment plan with a trustee, and it's much more involved. Those can take years. So if the person files a Chapter 13, even after we obtain our judgment, we're about to send the documents to the sheriff, we have to put a hold, and there's mechanisms that we can do in the bankruptcy court to lift the stay, because that hold is called a stay. So we can do a motion to lift the stay, basically arguing that the association is not receiving its assessments monthly, and this is creating a burden on running stuff. Yeah?
Do you have to be a U.S. citizen to file bankruptcy in the U.S.?
That's a good question. I do not know. I have to look that up.
Just curious.
But yeah, it's a whole other little world the bankruptcy stuff, and so either the board, we'll ask the board if they want to just monitor it and see what happens for a little bit. If it is, because sometimes these get dismissed, like if they're supposed to be paying $1,000 towards the plan and they miss 4 or 5 months of payments, the trustee will just dismiss the bankruptcy right then and there. But then of course you have the other cases, like I said, that are 2 or 3 years later, and the association, we can include it in the plan, and it can be receiving distributions. They kind of just deal out the money according to the priority in the bankruptcy, but it's not going to happen overnight. And unless we lift that stay or the case gets dismissed, we can't really move the case forward. So that's definitely a common hiccup, one that frustrates boards, because even if we're somewhere along the process they think they're making progress, and then it just slams on the brakes. And it's hard to predict when someone's going to file bankruptcy. We can let the boards know that that's a risk, but then they always seem to forget that that was a risk, because it's just hard to know. We can't say for sure this person's going to file bankruptcy, so do you want us to proceed? It's just kind of hard. And like I said, it can happen at any time in the process. The other common hiccup that we've seen a lot this year, which has been weird, are conveyances that don't go through title. So I kind of mentioned earlier that the association's lien is an automatic lien. So when someone sells a piece of property through title, they contact you guys or they contact us for a payoff on the amounts that are due. And again, whether that's after we file a complaint or after we have a judgment, usually the association will get its money through that payoff during the sale. If a sale doesn't go through title and someone just quit claims someone, here, take this property. Well, now it's owned by someone else, and but it didn't go through title, so the association didn't get any of its money. That can be confusing for boards because it's weird to do. Like, why didn't they go through title? They're doing some shady dealings. So the good news with that is that usually they do it through quitclaim deed, and that makes no warranties on the title. The association's lien remains for the new owner. So sorry, you're kind of a sucker because we're coming after you. We're going to still foreclose, and you just bought this property. So wouldn't recommend it to a friend. Don't, if someone's trying to give you a quitclaim deed, probably don't take that. But boards kind of get confused by all of that, because it's kind of alarming. Like, wait, they were the owner, and now this person's the owner, and how did that happen, and why didn't we get money? And so that's kind of, it's definitely be confusing. But the good news is that not all is lost. We can still go through the foreclosure process if this new person doesn't pay the amounts. So that's pretty much all I had. I didn't know if any of you guys had questions, if I said anything, went through something too fast, or yeah.
Just, if the bank beats you to the
Yes.
foreclosure, is it better just to wait to see what happens at the end, or do you put yourself in?
Yeah, so his question was, if the bank beats you to the foreclosure, what's the best recommended steps for the association? What we like to do, and it again depends on where in the process you are, but as part of our due diligence before we file a complaint is we check to see if any trustee sales are scheduled. If we find one that pops up that says, oh, trustee sale set for December, we'll kind of pump the brakes and say, instead of filing the complaint and incurring all these additional fees, let's see what happens in December. If it turns out that they're able to work something out with the bank and there is no sale, great, we can pick up right where we left off. If the bank does foreclose, we didn't incur a bunch of extra fees, that's the good news. And although the lien is extinguished, the personal obligation as to the former owner remains. So we can talk to boards then about possibly filing a lawsuit just for breach of contract to collect, if there's a way that we can collect through bank garnishment or for wage garnishment, or some other option where we can get those amounts that they're entitled to.
Plus you get a paying owner.
Plus you get a paying owner, you get the
Going
deadbeat
forward,
out of there, going forward. And another option that we kind of mentioned earlier is excess proceeds. So if the bank was selling it for $15,000 and it somehow got up to $60,000, we could try and get in on that piece of pie to satisfy the personal obligation.
put in for the excess
Yeah.
proceeds, what is that cost?
As far as fees,
Yeah,
I think it's somewhere between like 2,500 and 3,000. It's not a long process. It also depends on how many other creditors there are. So we just file what's called an application for excess proceeds. We have to mail it to everyone that's on the complaint, that's listed in the complaint, which is all of the creditors. That's why I said it kind of depends. If there's 20 creditors or if there's 4 creditors, it's going to be a lot cheaper and quicker. And then you have to wait about 120 days to see if anyone else kind of jumps in. If not, we get the money. Even if there are other creditors, like I said, we're usually first in line. So that's the nice thing. Unless the state's trying to jump in there.
okay.
Anything else? Cool, I hope that helps, and as always, just feel free to continue to email your board questions about foreclosure, but I just kind of wanted you guys to have an overview and an understanding.